Court of Appeals, First Appellate District of Ohio, with the Honorable Candace Crouch presiding, is now set. Please be seated.
Good morning, everyone. Welcome to the First District Court of Appeals. We have 3 cases for argument today, April 17. The first case is State of Ohio versus Carlo Jimenez. And I see we have Mr. Kachmer for the appellate.
That's correct.
Okay, good morning. And then Ms. Lapp for the appellee. Okay. After that, we have State of Ohio versus Woodard, and we have Mr. Gallagher for the appellant.
Good morning.
Good morning. And also Ms. Lapp again for the appellee. And then the last case today is In Re RM. We have Jessica Moss for the appellant.
Yes, Your Honor, and Shelby Adams.
Good morning. And Mr. Sauter for the appellee. Okay, great. So let's start with, am I saying the last name?
You were saying correct.
Okay, Mr. Carlo Jimenez.
You said it right the first time.
Oh, I messed up now. And Mr. Kachmer, would you like to reserve some time for?
Yes, I'd like to reserve about 4 minutes, Your Honor.
Okay, and there's going to be lights in front of you. When you have about 1 minute of your initial time left, the yellow light will come on,
Oh,
and the red light will tell you when to stop.
should I proceed, Your Honor?
Whenever you're ready.
Well, I guess we may as well just start with the issue of time on this case. It's our contention that Mr. Carlo Jimenez was not brought to trial within the confines of the Speedy Trial Statute. I will say up front that I was wrong about something. I thought that a ICE holder stopped the clock. It doesn't under Ohio law. And I think that's State versus Sanchez. It's 2006, 2093. So that's irrelevant. It does not stop the clock. Mr. Carlo Jimenez was arrested on April 9th, 2021. The first court appearance, I think, was on April 21st. The appellee is correct. I did ask for a continuance on that date. The trial was continued. There were 2 continuances, I think one on 21st of April, one on the 6th of May. After that, a motion to suppress was
Counsel,
filed.
is the May 6th continuance attributable to you? I noticed there was an entry put on, but that entry was not signed by you.
I noticed that too, Your Honor. I checked these this morning, and that one was not signed by me. You'll have to go with my memory on this. I think what happened was I was required in another court, and I think we had put it on the record that, I was asking to continue it. So there is, I think there's a record of it. I don't want to misrepresent this, but I noticed that this morning too. But I will say this, any contention that people don't want to touch these orders and nobody wants to sign them is just not true. I mean, they're signed. I filed a motion to suppress. The hearing was set for December 9th, 2021. We had the hearing. There were several motions. They were denied. At that point, there was a discussion, and it's all on the record, of setting a trial date. Trial date after negotiation, and by the way, I offered dates in January and February and even early March. But that's neither here nor there, because this is not on me. At any rate, it was finally decided that March 29th would be the date of the trial, March 29th.
Counsel, can we pause there? So,
Sure.
I've read the transcript. I know that you initially offered January and February dates and that there was some back and forth discussion. At some point you say, let's do early March. And by my calculation, early March would have been outside of the speedy trial time between December 9th and even, let's say, March 1st. That would have been outside of the time. So what do we do with the fact that you said, let's do a date that would have been outside of the time?
And shortly, you ignore it because it's not on me. I didn't ask for a continuance. We were going back and forth on dates, and the other 2 months had been rejected by that point. But under the case law, unless I ask for a continuance, unless I ask for something that would continue this trial, it doesn't count. It doesn't matter. It doesn't matter
You're
what I say.
essentially waiving time until the date that you agreed to.
Excuse me?
You're essentially waiving time on behalf of your client until the date that you agreed to.
No, I'm not. And the case law is completely the opposite of that. And I've cited several cases. Acquiescence by me does not stop the clock. And I think on page 17 of my brief, I've cited about 4 cases. It does not matter what I say. It is not my duty to bring this case to trial within the time limits. It is the court's and the state's duty. And again, like I said, the case law will state that. I can acquiesce, doesn't matter. I did not ask for a continuance. Now,
Was there a date that was selected by the court that would have been timely?
excuse me?
Or in that exchange, okay, was there a date that was not set, that was, that was suggested by the court that would have been considered timely, that you then said, no, I'm not available to that date?
I think the court said something about early January. I said I thought that was a little quick because it was it's a homicide case. Again, Your Honor, that doesn't amount to a continuance.
So when you responded saying it was a little quick, what does that mean?
It means that we have to prepare for trial. It was December 9th. Early January would have been about 2 or 3 weeks. That's what it means.
So then couldn't it be said that it was in order to accommodate you that another date would have been selected?
I don't know if you could say that. And again, I did not request a continuance. There is nothing on record saying that I did. We were discussing dates. Again, the case law, I think, is on my side. I didn't say, let's continue this. I didn't say, we can't do this. We said, could we do this in early January?
What would you be continuing? Was there?
Well, that's my
I
question.
mean, there wasn't it's not like there was a trial date already set.
No.
This was the parties trying to come to a mutually acceptable trial date,
Ex-
right? So
exactly.
this is more akin to a waiver.
Except there's no waiver. What waiver? It was back and
Speedy
forth.
trial waiver by agreeing to this trial date.
Your Honor, read the case law. It is not a waiver. And in fact, I think the very first case I cite, a defense attorney had called for a continuous. Judge says, I need a trial waiver. I need a time waiver. No waiver signed. It is not a continuance. It is nothing.
I understand that the continuance was not initially sought on behalf of Mr. Carlo Jimenez. I get that. Is there case law that would be akin to this where the initial request was not initiated by the defense, but there is a discussion and an accommodation with regard to the date that is ultimately selected?
I think the only case law that I can talk about is I think it's State versus Tope, and let's see, there's a prior one, State versus Singer, where it says acquiescence in a trial date outside the time period does not stop the clock. So the back and forth is just that, it's back and forth. And just saying, okay, we'll do March 29th it's not a time waiver. It's just not. It's nothing.
Counsel, in your perspective, what should the trial court have done to address the speedy trial concerns that you're raising in light of the fact that the early January date that was offered was too soon for you to be prepared?
You know, we keep focusing on that. I'll tell you what, it should have been a time waiver. That's what it should have been. Or it should have asked on the record, Mr. Cashmere, do you waive time? It was not done. And again, we can go and say, gee, Mr. Cashmere, you asked for a little more time in early January. You know what? That doesn't, well, number one, no date in early January was ever discussed.
But that's your issue here, is that the trial court didn't, even though you acquiesced to this date, you're saying that the trial court had to do a specific waiver on the record. And because he didn't do that,
Correct.
your client's case gets dismissed.
That's correct. And, Your Honor, to go back to address your question, let's say we had picked the date in early January. And I said, gee, that January 6th is terrible, I can't do that. All right? Well, there might have been some time between the motion to suppress and whenever date was set, but that wasn't the case. We were just having a back and forth about what dates would be available. If you read, I offered dates in January, I offered dates in February. The prosecutor couldn't do it. And then we had another date that was offered that the police officer couldn't do it. I mean, it was a back and forth. It was a discussion. There wasn't anything set. I did not say, I waive time. I did not say I want a continuance. As one of the panels suggested, continue what? What was being continued? The motion to suppress was over. There were no further motions until March 16th when I filed a motion in limine. The trial date the court had set, what was being continued?
Counsel, can you address what I anticipate will be your opponent's perspective on this issue regarding concerns about, I guess I'll characterize them as gamesmanship, that you didn't raise the issue sooner, that you brought it to the court's attention when the clock had expired? Can you just address that now?
Sure, I can. It's false. All right? Well, let me start first of all with it's not on me anyhow. I could be gaming as much as I want. It doesn't matter. The case law says that. But the fact is, it's not true. What happened was I had gone in I think about a week before trial, to basically go through some technical issues with the whiteboard and that sort of stuff. And on the way out, I thought, I'm going to stop by the jail. I knew there had been an ICE waiver. I had checked it a few times. It was always listed there was a hold on him. And what it was just a condition of his bond. It wasn't an actual hold. It was an ECU thing. And I said, does he still have the ICE hold? I called the jail, and they said, no, you don't have an ICE hold. I said, do you know when the ICE hold was taken off? Well, on the phone, they couldn't tell me. But when I had gone down to check the technical matters with the court, I thought, well, I'm going to stop by and see if somebody can give me a date when that ICE hold came off. And I walked over, and an officer at the information desk said, oh, well, that came off on April 13th last year. And that was the genesis of this whole thing. It's nice to accuse me of something.
I'm not sure that the state would accuse you of anything. I think the concern might be whether we would create a rule of law that would allow for gamesmanship.
Well, that rule is already on the books. And again, if you go to the cases I cite, you'll see that. Once a prima facie case is established that the person's been in jail beyond that time limit, the state is the person who's supposed to bring them to trial, not me. I could sit there and lie through my teeth. It doesn't matter. I know that sounds horrible, but it doesn't matter. It's not my responsibility to bring this to court. Now, that did not happen in this case. It did not happen.
Mr. Ketchum, you are at your time if you want to reserve 4.
I'll stop.
Okay.
Come on, Your Honor, counsel. All of the talk about cases that say, counsel, as he keeps saying, I can't acquiesce, it doesn't matter, I don't have to object. That's mischaracterizing the case law, because there is a lot of case law that says if you have had ample notice of the trial date, you cannot sit idly by and then jump up after time has run. Their cases say if you have been actively participating in the choosing of the date, which is exactly what we had here.
So those cases are, if counsel actively participates in the choosing of the date, they're not requiring any kind of on-the-record or written waiver, as counsel is suggesting should have happened here?
Well, but in this case, there is a waiver.
What is that
It
waiver?
was filed December 9th. It was-
Okay, it's on the sheet choosing the
Yes.
trial date.
Yes,
Okay, and it said defendant waives time.
yes.
Okay.
And under continuance, it was marked for defendant.
Gotcha.
And the electronic signatures are there.
Okay,
And when there were electronic signatures earlier, defense counsel didn't object to them. This is the only one he did. But the cases cited in his brief are not equivalent to what happened here at all. There was a case where there was no information in any entry or on the record anywhere about what the date was, to say whether there was a continuance, to say, whose it was. And in that case, time had expired. But there was no participation with counsel.
Counsel, the defense attorney has raised a dispute of fact about the December 9th waiver entry and whether phone authorization was given for his signature. Did the trial court have any obligation to create a factual record by, let's say, for example, bringing in the person who took the phone authorization to create a record that that authorization was in fact given?
On that date, there was no disagreement about it. I mean, on the December 9th. And what's in the record is what the judge said. What's in the record is the actual entry. And this court has to look at what's in the record. And then even when you go to the arguments where counsel was saying, I didn't continue this, the judge said, wait a minute, here is my memory of this. And they had the transcript from December 9th. And the judge stated in great detail why he was saying he was going to deny the motion for speedy trial.
All right, and I don't want to mischaracterize your position, so please let me know if I don't understand. But it's your position that at the motion to dismiss hearing, the factual record was created, and that was in reliance on the transcript from the December 9th hearing.
Yes, and the entry that was filed on December 9th.
Thank you.
And the other cases, like I said, that Tope case counsel mentioned, someone was arrested and arraigned, and a trial date was set. There were a lot of defendants in that case. And nothing happened until the trial date, and it was way outside of time. I don't even think the defendant had an attorney yet. So that case was dismissed on speedy trial. I guess I thought he would also talk about the sentencing. And I wanted to have a few comments. The judge did, at one point, go on and on about his own personal opinion about the current administration's immigration position. I don't know that that was appropriate. But
I appreciate you saying that.
I'm the granddaughter of immigrants. But if you look at the whole transcript, what he also said was, the reason he was looking at the immigration aspect of it was because the person had not shown up for a hearing, wasn't doing things according to law. He contrasted it with the fact that the victim was in the same situation, but did file everything appropriately and do what he needed to do to be a citizen. And he was saying, in terms of looking at someone, do you follow the rules? Do you follow the law? That was why he was considering it. And it started because defense counsel said the defendant had a low criminal history, but he had 2 prior OVIs. One of them had caused an accident. No, there was no indication whether injuries occurred or not, but he already had 2 priors. He had no driver's license. He'd been under suspension. All of that went into why the judge gave him the sentence he did. And there were comments about how the judge had treated defense counsel. But when you read the entire transcript, there were so many times the judge was being patient. And the judge said about getting clothes for the defendant. It had to be done. You have to have clothes brought in to the Justice Center a certain amount of time ahead. And apparently this did not happen. The judge still waited and made sure the family could bring in clothes. I mean, there were many, many times the judge was very patient. And only when it got to the point of him accusing the judge of not remembering the entry correctly, that hearing correctly, did the judge show frustration. But no, there were no motions for bias of the judge filed, nothing of that point.
Counsel, if we remove the inappropriate comments that were made and focus just on the sentencing factors, is there sufficient information in the record to justify the sentence that was given?
Yes. There was the prior OVIs, and this man was only 20 years old, I believe, and this was his third one. Also, you can see on the tapes what the prosecutor had said and the judge, a lack of remorse for anything. He did not act at the scene as if someone seemed to have any remorse for what had just happened. All of that was on the record and it was discussed. Those are the two I thought were going to be argued. Did you have any other questions about other assignments of error?
I don't think we do.
All right.
Thank you very much.
Thank you.
Mr. Kutchmer, you have 4 minutes for rebuttal.
Well, first off, I'm mischaracterizing the law. That's interesting. I just looked at their brief. They haven't cited anything at all concerning this issue. They just basically said, I asked for a continuance. Now, I've cited the cases. I think there's maybe a half a dozen of them that have to do with my duties and the court's duties under the Speedy Trial Statute. It is very clear that the state must bring this person to trial within the time limit. It is not my responsibility. And unless there is something on the record that shows that I asked for a continuance, which there is not anywhere, the state's out of luck.
So
quite frankly.
just so I'm clear, the entry that was put on selecting this March 29 date, there's, at the bottom of the entry, there's a defense waives time indication. Is that correct?
I don't have the thing in front of me, but I know that it said there was a continuance. That's how it was entered.
Okay. Well, normally, there's, at the bottom, it says which party waives time. You don't know on that
I don't have it
document?
in front of me, but I will say this. I was never called. Again, what would I be continuing? And why would you call me? I was in court that day. I was physically there.
So that entry you did not sign?
I did not
And
sign it.
that's
I was
the one
never called.
that says per telephone authorization?
I was never called. And think about it. If I had asked for a continuance, why would you put by telephone authorization? I mean, both signatures have that, not just mine, but the prosecutor's. It's just for both of us. Why would you do that? If I had asked for a continuance, it would have read something like the defense asked for it just doesn't make any sense. What do you mean telephone approval? Approving what? What? I was in court that day. I was in court all morning that day. And again, I don't remember which one of the panel, but once I make that 90-day, I show that 90 days has passed, the burden goes to the state. The person who made that phone call did not testify. And the judge was not a party to that phone call. Has the state met the burden? They haven't done anything. Let's go. I just want to move on one more time. We got on the time thing, but this is volume 15 of the transcript. This is the judge's comments at sentencing. Like so much else in this case, it's not just the judge, it's police officers too. Facts that are not in evidence are used against my client. The judge, after his tirade about the invasion and everything, and by the way, I'm second generation. My wife was a naturalized citizen, so this hits home too. After the tirade, I mean, we can selectively go through this, but you can read it, it's 22 pages. He says, and you showed no remorse. You went to sleep with a smile on your face. Where is that in the record? Where? Where is that? This was just insane. I mean, I was standing there and couldn't believe it, hearing it. But at any rate, I think if you go through this, there's a pattern for instance, for the police officer's reports. He puts things in there that didn't exist, that he admits he made up. In his affidavit for the search warrant, whether you find standing or not, he made stuff up. And he admitted it on the stand. That's the pattern in this case of making things up. Again, I never signed for a continuance. I never agreed to a continuance. The burden shifted to the state. The state offered nothing other than the judge saying, we speak through our entries. There would be no reason to ask for a continuance. There'd be no reason for me to have a telephone approval. I was in court. Why would you call me? I'll tell you why. The CYA thing, it wasn't for me. It was for somebody else.
You are at your time.
Thank you. I'll end on that note.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision. The next case is State versus Woodard. Mr. Gallagher, would you like to reserve some rebuttal time?
3 minutes if I could.
3 minutes, okay. And I will try to work the lights in front of you so you
Okay,
know.
I'll try and pay attention. May it please the court. Counsel? I'd like to start, if I could, with the issue concerning the jury instruction and the failure to give the lesser included instruction. The trial court, in this case, committed a reversible error in refusing to give that instruction. The standard of review for that is, though, as you look at it, is in the light most favorable to the defendant. And so the facts in this case have to be viewed through that light. That's the Ohio Supreme Court has said that in a couple different cases. So in that case, what I would suggest is what that means is that the defendant, Jarrell Woodard, had no knowledge of the weapon before it was used. That was on his brother Jace, and that there was no agreement between the two to use deadly force. And I think there's some evidence to support that in the record. One is Jace's statement after being stabbed, at which point he says, wait, you just stabbed me, and then shoots. And it would suggest that that shooting was not pre-planned, but was in fact in response to Mr. Killings pulling the knife and stabbing him when he was being hit. Also, I think it also is supported by the fact that there was this assault, a physical assault, with the two brothers on Mr. Killings. If there was this intent or there was this agreement to shoot, why come in and use your fist? You would just come in and then shoot. And like I said, we're reviewing this in the light most favorable to the defendant. And that it was the knifing that escalated what was supposed to be just a physical confrontation. And I think that's also supported by the Bill of Particulars. When you read the Bill of Particulars, what it claims is that the defendants punched Mr. Killings about the face, period, and then describes the shooting, which is also an indication that there are two separate acts here. And that was what defense counsel began to argue to the trial court. The trial court said no, and in essence put forth this sort of standard, I think, review of what we see in most felonious assault cases that involve a dangerous weapon, that these were charged in the alternative, a single act involving a weapon. One that you attempted to cause by means, and then there was serious physical harm. And in a case where someone's shot, that seems to be pretty straightforward. And they discussed this when discussing the lesser included.
Counsel, let me ask you a question. So by the trial court seemed to deny the motion for lesser included based on an exclusive theory of shooting.
Correct.
And didn't that change the state's theory of the case? Wasn't the state operating under this kind of course of conduct idea that there was both a physical altercation and then a shooting?
Well, I would suggest that it changed for the most part in rebuttal. When they were arguing the jury instruction, that was not what the state said. The state agreed with the trial court, if I could. I think it's around page 319 was the discussion about the lesser included. And in that discussion, Mr. Lewis at the very end of his conference said, the state is filing complicity for the shooting and serious physical harm. And the court says, and that's all. Basically, he's thinking that this is all about just the shooting and nothing else before that. And that was, in essence, what the state said in its opening to the jury, was that this was just about a shooting, and for the most part, in the closing argument. But then in rebuttal, after the defense had already talked about it, then starts to talk about how Mr. Woodard, Jarrell Woodard, the defendant and appellant in this case, said in the course of conduct, starting with the headbutting and the punching. That's not what was charged in the bill. That was not what their opening was. That was not the way that they argued this during jury instructions. They were claiming that it was just about the shooting. Now in rebuttal, they're telling the jury that there's a completely different theory on it, and there's only one way for this jury to vote on it because they weren't given a lesser included. They weren't given the opportunity to decide whether or not this was responsibility for the shooting, or the harm, I should say, or was it about the headbutting or the punching.
And the jury's verdict suggests that they may have attributed.
I think it has to. I mean, it's a fair reading of it. There was no dispute that there was a gun. There was no dispute that Jace Woodard shot Mr. Killings. Everyone agrees to that. No one disputed that at all. Yet the jury found Mr. Woodard not guilty of the attempt to cause any sort of harm by means of a dangerous weapon. The dangerous weapon was there.
He was charged, though. I mean, I agree with you, the bill of particulars was a little confusing, and I agree with you that the rebuttal got a little confusing. But as you stated, it was very clear, the opening, the main closing from the prosecution, the entire discussion of the lesser included indicated that both counts were based on complicity to the gun.
Correct.
And even defense counsel, when the judge said, no, I think this is, it's all based on the felonious assault, he says, I agree. It makes sense when you put it that way. So defense counsel even agreed to that.
I think, well, I guess you have to figure out tone. That's always nice if we have videotape, right, to understand exactly whether he's agreeing that the state's comment of that's their theory, or is he agreeing that that's the only way? Because he had asked for the lesser included on the harm, and in fact took the time even to file a post-conviction Rule 29 motion or asking to go back through it again.
Right, but then the jury was charged with complicity on count one.
Right.
Which makes me think that, the only way he can be charged with complicity is for the gun. So he's charged with complicity on count one and count two, right?
Well, he's charged, but that's the only theory that could be available when you charge him as co-defendants. He clearly was not the principal, and the agreement was not as a principal. So the only theory that he could be convicted involving the gun
For the shooting.
For the shooting or for any use of the gun. It has to be
But you're
complicity.
saying count one necessarily, because the jury acquitted him of count two, count one necessarily has to be a guilty finding based on him punching the guy.
No, what I'm saying is if I first think that there's insufficient evidence on count one. I mean, as a matter of law, based on that inconsistency in the verdicts.
Based on the idea that count one is based on a punch, not a shooting, right? That's your insufficient evidence argument, is that the punch didn't cause serious physical harm.
Correct.
Right, so you're assuming that count one is based on a punch.
I can't assume that, but I mean, for that argument, I'm saying yes. I mean, so there is also, yes, there has to be. Or there could be lasting
It can't
complicity.
possibly be based on complicity to the shooting.
But the complicity also to the shooting would have to be based on knowledge. And that becomes a question to begin with as well. And there's a question about whether or not there was a knowledge or an agreement in terms of the shooting itself, or was there just an agreement to punch? Was there just an agreement to beat up? And was that agreement to just do that?
So your count one insufficiency argument, I think I kind of read it as it was insufficient because it had to be based on a punch, and the punch didn't cause serious harm. Are you also saying now that there's insufficient evidence if it were based on the shooting and complicity to the shooting? There's insufficient evidence on that basis as well?
I think the complicity fails, yes.
Okay.
I think the complicity easily fails on that. But there should have been a lesser included based on the way the bill of particulars, I think, first of all, set this forward. And second, based on the evidence in the case, because it's clear that there was in the light most favorable to the defendant, and that's what the trial court should have looked at, going, is there a place in this? Could this have happened? And that's, if I could, I think that's the sort of the Cochran case. When you sort of read that language that comes in there, I think it first comes really from the Ohio Supreme Court, which is the second thing you begin looking at is whether a jury could reasonably find a defendant not guilty of the charged offense. That would be easy in terms of the physical harm aspect of this in the shooting, but could convict a defendant of the lesser offense. And only in the second tier of analysis do the facts of a particular case become relevant. And so that's why it's always sort of hard to find analogies, right? Because it really sort of drills down to the specific facts of the case about whether or not that gets given. And I think that clearly in the light most favorable to the defendant, there is that presence in this
Counsel,
case.
to your point, we're looking at what could have been charged and believed by the jury, not what must have been. And I'm looking at language in the bill of particulars that says that Jace and Gerald punched the victim in the face. That language would have been irrelevant and superfluous if count one was entirely based on the shooting, right?
Yes. Yes. But from the very beginning, when questioned, the state only said, before rebuttal evidence, that it was based just on the shooting. Opening statements talked about the complicity for the shooting, jury selection, complicity for the shooting, arguments about the jury instruction, complicity for the shooting, closing arguments, complicity for the shooting. And then later decided that it was an entire course of conduct that started from the very beginning of the headbutting, for which everyone agrees that there was no damage whatsoever because I mean, the hospital, Mr. Killings, Officer Blackwell, and everyone said there's not even anything, there's not a bruise or discoloration or anything else at all like that. So there clearly isn't serious physical harm. So at best you have an assault that doesn't really require anything other than the contact that everyone agrees occurred in this case.
And so it's the rebuttal that changes the state's theory?
I think that's, I don't know if it changes their theory or if it just, I don't know how to really characterize it, but I think that that's what one could look at that says that's what led possibly to this jury coming back with the decision that it got when thinking about complicity, as opposed to just some general sort of compromise that we're going to catch him a break.
But is that the moment that the judge should have reevaluated whether or not she was going to give a lesser included?
Yes, I think.
I mean, because before that, as you said, the state had one theory, and it was complicity to the shooting, and you're saying the rebuttal kind of changed everything.
Right. And I think even if it somehow missed, and we all miss things, I consistently miss things all the time. If it got missed by the trial court, then there was an opportunity post-conviction to reevaluate. I think in that sort of moment of calmness that we now reevaluate almost everything afterwards because we have an opportunity to sit down and do it, that trial court had that opportunity and should have taken that opportunity then, and for whatever reason did not on it, and that's why we're here.
Was it raised by defense counsel after rebuttal? Like, hey, judge, look what they said in rebuttal.
There's nothing in the record of that other than obviously you have the re-argument about submitting the lesser included, right? There is that. So you saw the reaffirmation of I get my lesser included.
After the closings were finished.
Right.
Okay.
For jury instruction, there was a reaffirmation, I think, for that. And so I would suggest that without more argument is enough evidence to suggest that the defense counsel was still pressing that matter.
I'd like to go back to the language in the bill of particulars and to the same language. It says the defendants, Jace and Gerald, punched the victim in the face, okay?
Mm-hmm.
So, you know, these are the facts for the bill of particulars, right? And your client, count one, is charged with the felonious assault. There's no facts other than the language of the statute causing serious physical harm, right?
Right.
So going back to the bill of particulars, I mean, there could have been serious physical harm with the punching, right?
Possibly there could have been, yes. Yes.
So the issue is, what's the evidence that's presented?
Yes,
At
ma'am.
the end of the day, right?
Correct.
Okay.
That-
And then it says both of them had punched. How does that go to complicity, and does it go to complicity at all?
How does it?
Yeah.
I'm not necessarily sure if it, in terms of the serious physical harm, I'm not necessarily sure if it, there's clearly complicity for the assault. There's no doubt at all. There's complicity for an assault. There's not complicity for serious physical harm, because there was none resulting from the punches. And there's not enough evidence at all about the complicity, I think, with the jury's verdict on count 2 for them to say that there was complicity for the shooting, because the jury had already determined that there wasn't complicity for the shooting.
So if the state was presenting complicity, is that inconsistent with the bill of particulars in its having a statement of complicity for the assault?
I'm not necessarily, I don't know if they had all the evidence at the time they wrote the bill of particulars in terms of the hospital records or not, so I can't say exactly what was in the mindset of the prosecutor at the time that they filed that bill of particulars, because I don't know when the medical records would have gotten to them. And so it's very conceivable that without the medical records, just assume that there was some serious physical harm. One person went to the hospital and 2 people were beating him, and it would be hard to imagine that there wasn't something much greater than there was actually in this case. So I don't know that for sure.
Okay.
Counsel, wasn't there evidence in the record that Gerald brought Jace into this encounter? And
Yes.
so wouldn't that have been, in theory, a complicity pathway for the prosecution as to an underlying assault as well as the shooting?
I think for the underlying assault, yes. I think the underlying assault, that there's clearly the evidence for that misdemeanor assault. There's no doubt. I got something for you. I'm bringing my brother. Here's the 2 of us, and we start beating you. The problem I suggest is, even without the evidence most favorable to the defendant, is there are statements and actions that suggest that the shooting was never part of this, that the gun was never meant to be part of what was going to occur. Because if not, why not just shoot him? You don't need to engage in this physical confrontation with someone that you know that has a knife. Instead, the 2 of them go, you got a knife, I got 2 of us. And they start beating on him. And then Mr. Killings slices away at Mr. Woodard, who responds, man, you just stabbed me? And then pulls the gun and then shoots him. And I would suggest that those shows basically a separation of actions for which there was not complicity at that point.
Well,
And
that
it
was
would be
already
easy.
determined by the jury. What's the significance of the bill of particulars?
Well, I think it puts you on some notice in terms of what some of the acts are that underline it, but it doesn't necessarily guide a jury in its determination. I think that it at least gives notice to the defendant in terms of how it is charged and what to expect, and the fact that they separated at first those with the period as opposed to the course of conduct that you sort of saw in the rebuttal argument. Gives you some further evidence in terms of what to expect, and it didn't change. Everyone went along with that until, it turned up to rebuttal evidence, and then it was also, I think, very confusing for the jury in terms of how to go forward with that count 1.
So what should the state have done at that point then? Or could they have done anything?
Well, I think that one is that obviously if that was a back theory in the back of the mind, it should have maybe spoke up at the time of jury instruction, as opposed to the judge who had said this is really only about a shooting, that's it. And the state said, oh yeah, we agree. They should have said, no, it's much more than that. It starts at the very headbutting, or it starts with the punching. At that point, maybe there would have been a different discussion about whether the lesser included was in there. But I think that maybe they should have been a little bit more forthright in what their theory was and what they were going to tell this jury, because they did tell them something very much different in rebuttal. I think I'm probably out of my time, Martin.
You're way over, but we asked you a lot of questions, so you can keep your 3 minutes
All
for
right,
rebuttal.
we'll see. Maybe I don't need it.
Okay.
Your Honor. Mr. Gallagher?
Can I ask a quick question? What's the reasoning for charging count 1 and 2 in the alternative for the same act?
Because 2945, I believe it's 72, allows it, the state, and with complicity, because the state does not have to charge someone as a principal, they can be convicted as a complicitor. The 2 counts is because felonious assault can be charged in both ways.
And it's not a different penalty, right? They're the same ultimate penalty.
Yes, because there was no firearms spec involved.
Okay.
Um,
So,
Well, there might have been for Jace. I don't,
so it's just it's kind of odd because, you have this bill of particulars that seems to indicate that count one might be based on the punching and count two would be based on the firearm. But then later, the state says, no, we just charge this firearm complicity two different ways.
well, the bill of particulars is not evidence.
I understand.
And it was written with both defendants in mind. That paragraph is being cited with the description was for counts 1, 2, 3, 5, and 6, both Jace and Jarrell. And it's not evidence. It's as Mr. Gallagher said, it comes on very early in the case.
So the bill of particulars that we see, the state doesn't go through each count and say, okay, count one is this, count two is this, count three is this. It kind of just lumps everything together. Is that what it does?
This one did. And this was not, I mean, you know how the person who wrote it isn't the person who tried the case. It was done September 10th. I'm not sure the date of the trial. But it has to give more than what the indictment said. So they add facts.
But they don't add facts per count so that it's clear what count one is concerning versus what count two is concerning, right? It's like everything just seems to be lumped together into,
In this
One
case, it
narrative.
was definitely lumped together.
okay.
But on the issue of the assault, if you look at, and the jury saw the video, and the jury saw the interview of the defendant, and under no interpretation could that have been misdemeanor assault. That would have been proper as a jury instruction. And when you,
Counsel, why is that? Can you break that down for me?
because it shows how they were acting in concert. First, you've got Jarrell with the victim. And at one point, it's a back and forth confrontation because the victim's trying to help the woman that was with Jarrell. And as he's getting to Jarrell, the victim says, I've got a knife. He had a little knife and he's showing it. And then Jarrell says, oh, well, I've got something for you. He runs out. He and Jace come back in. And this whole thing happened with, I want to say less than a minute. They come back in, go right in, and you see the gun being shot. Both brothers are together, approaching the victim. There's no interpretation that that could be a misdemeanor assault.
But it's based on it's not, but your argument is that nothing's based on the punching, right? Even though the prosecutor's rebuttal seemed to indicate that maybe the punching was part of this?
He made one sentence, but the prosecutor gave one sentence in rebuttal, and that's what was quoted. But if you look at the entire rebuttal argument, the prosecutor went on to talk about this is because of the shooting.
Okay.
And no, I don't believe they weren't solely indicting because of punching.
What was the purpose of including that sentence in the bill of particulars? Because aren't we bound to the bill of particulars? Isn't this intended to give
No, the
notice?
bill of I'm sorry.
Isn't this intended to give notice?
It is intended to give notice, but that's before they've even gotten discovery. And so later you get the medical records, police reports, statements of interviews.
But isn't this intended to give notice of what what the grand jury indicted on?
It is supposed to be a general notice, yes, but it's not evidence. Because at that time, defense counsel
Well,
didn't even have.
It's not evidence, but, so what was the purpose of including that? What
I
was-
think giving a total picture of what happened. I don't think there's any error by saying that he went in first and punched him and then got his brother, came back, and they both attacked him, and Jace shot him.
Counsel, what do we make of the fact that the jury acquitted on count two?
that you can make almost nothing out of it. You cannot go into the minds of the jurors. You can't go back and try to guess what they were saying or make any assumptions. As all the cases say, they could have done it out of mercy or lenity. And Woodard got the benefit of the acquittal on the shooting with the gun, complicity to it. When verdicts don't have to be rationally reconciled. I mean, the case law is so totally clear on that. And you just can't speculate on it. In this case, it worked to his benefit.
How so?
Because they acquitted on the charge with the gun.
That's what I was asking, what's the difference between count 1 and count 2 ultimately?
Oh, you mean
Penalty-wise.
sentence-wise?
Oh, yeah, I mean, is there a difference in sentence?
Off the top of my head, I can't
Well,
answer.
I didn't think there was. And so that's why it's kind of confusing why the state is charging the firearm charge in the alternative in this case.
Because of the complicity, because of how this thing could have ended.
But both are complicity, right?
Yes.
So he's being charged with 2 counts, 2 different ways that have the same penalty
Yes,
for the same action.
yes, because the state has the right to do that, and by statute. And the jury can look at both charges, convict on one, none, or both.
So if it's about the firearm, you're saying that even though it's about the firearm, the state can charge on A1 and can also separately charge on A2?
Yes. Yes. You know, the time of charging, you know what witnesses you're hoping you're going to have and what you plan on, but so many things can happen between then and trial. But especially with the video here and the interview of the defendant, just not even looking at Jace's interview, because that wasn't in the record, but Jarrell's, I think the evidence is solid, and the jury could have convicted on either one or both. And if they had convicted on both, it would have been an allied offense, without a doubt. But the rebuttal argument, I'd say you have to take it as a whole. Because, yes, they explained about the punching. You know, they also explained about every aspect of what happened during this encounter with the woman, they called her Boney. You know, all of that was brought in, but it was the coming in, running in with him, gets him, comes right back with the gun, and they both approach him. And I think that's so clear in the video, and then when you listen to his explanation in his statement.
So you don't think the bill of particulars or the rebuttal argument does anything to change the state's theory of what count 1 really was
No,
about?
and especially if you read the entire rebuttal argument, not just picking and choosing phrases. Any questions?
Thank you.
Okay.
Mr. Gallery, you have 3 minutes.
Appreciate it. There is, it's the exact same sentence if there had been available, it would be 2 to 8 years.
Also, I'm trying to figure out why charge.
I think maybe sometimes it depends if there's a lot of actions going on. I think that there could be an argument that had Mr. Killings shown up at the hospital with a broken nose and maybe some other injuries that were separated from the gun, that there could be an argument that there was serious physical harm, even if Mr. Woodard wasn't
I
responsible for that.
understand that, but I don't understand if this was what brought to if this was brought to the jury, and I could understand that perhaps, I don't know, the bill of particulars can just want to have a nice, discussion of everything that occurred. I get, okay. But if this is what was brought to the jury, and this is what the jury indicted on,
Right.
then, and what was brought to the jury was on the firearm, not on the punching,
Right.
then I don't I'm still trying to understand the A1 and the A2. Because on the firearm, why would the jury possibly indict on, fine on the A1 and yet not on the A2?
Yeah. I mean, I would have at least some disagreement with my opponent on this, which is, it wasn't just a single sentence in rebuttal. I mean, from the very beginning of this case, what the state was saying in opening statements, before the jury even started, their charges were alternatives. They didn't say separate or anything else like that. They said alternatives, all right? And then in closing argument starts talking about the injury. So there's scarring. So there's your serious physical harm. 427 is where the serious physical harm, nothing else. Not attempting to claim anything else caused serious physical harm, just the scarring that happened from the shooting, and talks about being a complicit or an aider in it. But in rebuttal, it's more than just a sentence. And it's 448, 449, and 452 of the transcripts. And you are going to be considering these charges individually, and we talk about two separate charges. So we're not talking alternatively, now we're trying to tell the jury that there are two sort of very, very separate charges. And so if you don't believe Jarrell's intent was for Jace to shoot him, his intent was to beat him up and cause harm. Well, that charge is serious physical harm, not harm. To cause harm is an assault, which is what defense counsel had been asking for and was refused. And so now this prosecutor is basically telling the jury that the intent to cause harm can serve as the basis for the charge of serious physical harm. And then later on, 3 pages later, says Jarrell started this entire series event in motion. He got his brother, brought his brother in. He knew their intent was to cause serious physical harm. They are going to punch this guy for getting in his business. They're going to punch this guy. That's the assault, but now trying to claim that this is enough for count 1. And the suggestion is that that's why there should have been this assault instruction. There really, really should have been. And without it, this jury was not provided with the proper instructions for them to then apply to the facts as they found them.
Is there case law out there? No, that's okay. It's okay.
Go ahead.
I'm not making your job easy today.
No, that's okay. That's okay. We like questions.
Is there case law out there that says, for the purposes of felonious assault, that serious physical harm could be understood from the facts without the actual presentation of injury and such?
I don't think so, because all serious physical harm, and there's a lot of sort of case law that supports to what extent serious physical harm can be, but it clearly requires things like hospitalization. They talk about scarring. They talk about things such as that that's required. But it just can't see that it requires some evidence to support that finding.
Well,
Right.
but the facts itself is some evidence.
But I don't think you can just say that because that's the reason why we have a difference between assault and felonious assault. So we don't really require any injury whatsoever for us just to have an assault, where people can come into contact. Mm-hmm. There can be a moment of pain, there can be discomfort, there can be all those things, and that's an assault, even though you don't see anything. We can imagine that, right? We can imagine when we see 2 football players collide that even though there's not serious physical harm, there is some discomfort in that. And that's why we have assault. But serious physical harm, we require something more than that than just imagine. We require our ability to perceive or see.
Wasn't there also a video that the jury would have seen that would have captured the punch?
Yes, and it did. And it did. But there was also then the testimony from Officer Blackwell said, not a mark on him. There was a hospital record, not a mark on him. And even Mr. Killings didn't say it. When he talked about all the harm that had been caused by the shooting, he talked about the fear going out, he talked about all the effects of the shooting. Not once did he say anything about even the level of discomfort that happened from the punching at all. For you to then maybe say that might be, or a jury can consider whether that could be serious physical harm. Everyone in this case, even the prosecutor, agreed that there was nothing that happened from the punching. It was all from the shooting. But wants to include that assault as somehow the rebuttal, changing it without the lack of that instruction. And the court had a couple opportunities to give that proper instruction, just failed to do so. And I would ask this court to remand it with a new trial in the fact that there should have been that instruction, or In the alternative, and I think that even just as strong, you can say if there's insufficient evidence, and in this case, it can be done, and Mr. Woodard, should be released. I appreciate your time.
Thank you. Thank you for responding to the litany of questions.
Okay, this case is now submitted, and we will issue a timely decision. Have a good rest of your morning. Last case today is In Re RM.
I need these.
Ms. Moss, would you like to reserve time for rebuttal?
Yes, Your Honor, 3 minutes.
3 minutes, okay.
Morning, Your Honor. Mr. Tauter, may it please the Court. Jessica Moss and Shelby Adams on behalf of the appellant RM. This case is about RM trying to seal and expunge 6 of his juvenile delinquency charges. And the assignment of error is broken into 3 separate issues. The first is whether or not the juvenile court erred in deciding to deny seal and expungement of RM's juvenile charges when he was rehabilitated, and this decision was contrary to the purposes of the juvenile court system. And we know sealing and expungement procedures are remedial in nature and are supposed to be liberally construed and liberally granted. And this, especially for juvenile delinquency cases, promotes the goals of the juvenile court system about reintegration in society and leaving the juvenile youthful offenses in the juvenile's past.
How many years before he filed this motion for expungement had he been out of the juvenile system?
His last juvenile adjudication was in 2017, so that was 4 years before he filed these applications.
Well, he was out of the system since 2017?
So he was out of the system. He
thought-
turned 21 in 2021.
Okay, and was he still involved in the system in some way up until then?
He was released from DYS and released from parole, so there was no outstanding court orders.
Well, there's a 2019, breaking curfew and cutting off an ankle monitor right, situation in 2019?
So there wasn't a separate charge. There was a violation at one point on one of the charges, which resulted in the one restitution order. But
the 2019 violation came from the 2017 adjudication?
correct, there was not a separate charge for cutting off the ankle monitor, and that goes into one of the second issues presented as to the restitution charge, that this was not a properly ordered restitution from the beginning. Restitution is part of the underlying offense. And
But
now,
before you get into the restitution, I'm just trying to understand, because we're talking about sufficient rehabilitation, and he had a 2017 juvenile adjudication. 2019, he breaks curfew, cuts off his ankle bracelet. He then my understanding, he has subsequent misdemeanor convictions as an adult in 20 and 2021, and then files to expunge in 2022?
it was in 2021,
In 2021.
yes.
And so he's trying to make an argument with all of that he's sufficiently rehabilitated at that point.
That it's not sufficiently rehabilitated, but it's satisfactory
Okay,
rehabilitation.
and how is he how are you saying the judge abused her discretion in finding that he was not satisfactory rehabilitated?
So he was working, he was employed at a factory, filling shipment orders. He was also close to earning his high school diploma. And while he was at DYS, he did utilize that time and participated in numerous services, including mental health therapy, grief counseling, substance abuse treatment, victim awareness, and life skills.
Is the threshold for satisfactory rehabilitation different for a juvenile than an adult?
So I don't know that it's clear as to what constitutes satisfactory. I think we're looking at a pass-fail. I don't think it's 80%, 90%, 100%, certainly not. I think it's just enough. And for the difference between juveniles and adults is for adults, you're weighing the state's interest in maintaining the charge versus the juvenile's interest in having the record sealed. And so when we're looking at juvenile charges, if this is supposed to be liberally construed and liberally granted, we're looking at what's this bare minimum does he have to pass? And that's part of the problem with this consideration of restitution as part of this analysis. So in my brief, I separated the restitution into the second issue as part of the whole assignment of error.
Don't you think this was a little bit soon to apply for sealing and expungement? Because he just gets out of the system. He still has some misdemeanor convictions. He hasn't even gotten his GED yet. He had just started with this company. I mean, don't you think perhaps it would have been more successful if he had a little bit more time under his belt doing all this good stuff that he was starting to do?
I think certainly may have been more successful at that point, but I don't think he's precluded from trying to pursue this at this point in time. He indicated that he was even denied employment at one particular point because of outstanding charges against him, and so that was part of this motivation to try to have these records sealed and expunged.
Because he wasn't able to find jobs.
Correct.
Okay.
And again, I know the court, you have mentioned, the adult charges, these were also only misdemeanors, these were not felony charges. And again, all of these things show this satisfactory rehabilitation. Now, the second issue is whether the court can consider this outstanding restitution prior to a person turning 21, determine that that's a circumstance that relates to the rehabilitation of the person at the time the court's making this decision. And this issue is broken into two further sub-issues. First is whether they can consider this at all. Now, at the time of the full seal and expungement hearing, as well as the objection hearing, RM was over the age of 21. And restitution is only ordered as part of a dispositional order that ends when a child turns 21.
Now, just to be clear, at the time he filed his application for sealing, he had not yet turned 21.
Correct.
So, I mean, arguably, he could have paid the restitution at that point.
He may have been able to pay, or there was that opportunity, but also he was indigent at the time that the restitution was ordered. He was also indigent at the time that the sealing and expungement hearings were happening. And in the 5 months between him getting out of DYS and turning 21, you have somebody that was in DYS for a period of time and is trying to get their life back on track, and that's a very short amount of time to do that, as well as to pay the restitution order. So I certainly.
Counsel, do we know how heavily the juvenile court weighted the failure to pay restitution? We've discussed some other factors that the court considered in looking at the rehabilitation question. Do we know how much this restitution issue played into what the court ultimately decided?
I think at the hearing in front of the magistrate, she indicated that there was this moral responsibility and obligation to pay the restitution, and so I think that shows, certainly a consideration of that. But even if we were 10 years down the road for RM, this issue of restitution, I think, would come into play even if he had committed no other offenses in that remaining period of whether or not the court can consider this outstanding amount.
It sounds like most juveniles are going to have I don't know the answer to this question, but it seems like if they're being released and they're going to be turning 21 pretty soon, there would be a large percentage of juveniles that don't pay restitution.
I think that would be accurate. I think it would
I know
be
it's
very
not on the
difficult
record,
in
but-
terms of, being able to be employed and what they're doing, or if they're at DYS of having that ability to pay. But certainly that is a problem affecting juveniles to be able to do that, and shouldn't be used then later on to determine that they're not rehabilitated at that point in time, once after they're 21. Additionally, restitution was only ordered on one of the 6 cases, so even if the court could consider restitution, it certainly should not have been a factor in these other 5 cases. And additionally, the restitution was not properly ordered because it was ordered not as part of the initial disposition, but ordered because of cutting off this ankle monitor as part of a parole violation. And damage to an ankle monitor is a separate offense. It's either criminal damaging or vandalism. It's not its own offense. So the state and the court were not a victim that would be entitled to restitution.
But we
So-
can't go back on that in this proceeding, right? I mean, restitution is what it is. Like, how do we go back? You're litigating a restitution issue that probably should have been litigated on direct appeal, right?
I think certainly this should have been litigated on direct appeal, but I don't think we're barred by res judicata at this point in time because the court, General Assembly directed that the juvenile court may look at the nature of the case. And the nature of that case is the fact that restitution was ordered. And so if the juvenile court is going to consider this outstanding restitution, certainly how that restitution was ordered should be part of that analysis.
Counsel, parole is part of the rehabilitative process, and its purpose is to try to help a person reintegrate into the community coming out of a prison environment. How a person fares while on parole certainly would be a part of a court's consideration in terms of how a person has been rehabilitated. Can you address that aspect of a court looking at rehabilitation with a person who's been on parole?
I think had the juvenile court here had a factor that, he had cut off an ankle monitor and used that as a basis to determine that he was not rehabilitated, I think that certainly would have been a factor the court could consider, not the fact that he didn't pay that outstanding restitution during that time period, the 5 months that he was out of DYS, to say he was not rehabilitated. And the third issue within the brief was whether or not the court should have granted the request for sealing expungement in case number 16-4858 and 4859, which were the cases that were bound over to adult court and dismissed in adult court.
Do you have any case law that would allow us to treat the bound over case as the same case for purposes of the Pepper Pike argument?
There are no specific cases out there. There's very little cases about juvenile sealing expungement to begin with, so we're limited with that. We have the State v. TD case that talks about adult cases of a refiling of an adult case, where one case was dismissed and refiled that was the same circumstances, the same fact pattern, the same basis for the charge, and the 2018 case is the same case as the 2019 case that was refiled later.
Those are different case numbers, but they're treated as the same case.
Correct. And here we have the juvenile court proceedings, which are going to be one case number, and once he was bound over to adult court, different adult case numbers. But effectively, the adult case is what's going to encompass the entire case, the juvenile court case as well as the adult case, whereas the juvenile portion is just going to talk about the initial period of the case without indicating what happened further.
RM has not yet moved to expunge the adult component of the case, right?
There was nothing in the record about him trying to have the adult portion sealed. However, I think what's problematic and what's part of this argument is the fact that if that adult record gets sealed without addressing the juvenile part of it, there's no way to know what happened to those charges for anybody else to know that those have been that those were dismissed. And so I think that's problematic, and that goes to why it's so imperative and why we're urging that this court utilize the Pepper Pike extrajudicial authority to grant sealing expungement of these records.
Wouldn't your argument have been stronger, though, if you would have sealed the adult record first and then made this argument that, well, now, of course, you have to seal the juvenile record?
It may have been. I think it could go either way. I think, again, the concern is the fact that if we get rid of this adult one and we're denied in juvenile court, then he's left with a situation where these records are still hanging out there without showing the public or anybody else that this was actually dismissed, since that would show up on different background checks or reporting employment, things like that.
And you are at your time if you want to reserve 3 minutes.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court, counsel. I don't have a lot to add to what's in the brief. I would note that while this case was pending, this court released the In Re LP, which I believe Judge Krause was the author on that. This case is essentially indistinguishable from LP, and to the extent that it is distinguishable, I think it militates more strongly in favor of the trial court's decision in this case. We have continuation of criminal conduct. We have very serious offenses that he had when he was a juvenile, short amount of time in this case between the end of juvenile jurisdiction and the time of the application. To the extent that the court considered restitution, that was addressed in LP as well. I think that there was no more weight given the failure to pay restitution in this case than was the case in LP. I don't think it could be shown that it was first of all, that it was an impermissible consideration, or that it carried the day as to the finding of no rehabilitation.
Aren't most juveniles, though, going to have restitution kind of hanging out there just because they age out of the system?
Yeah, I think that's a conundrum, Judge, but I mean, the propriety of the restitution order, as the court suggested earlier, it's probably something that should be addressed at the time of the disposition of the juvenile case, whether there's going to be the ability to pay or the propriety of the restitution order to begin with, as with the ankle monitor. So I think it's probably a little bit late in the day to be looking at that And in this case, as I said before, I don't think it carried the day in any event.
You're
As for
saying
the-
it didn't, the judge didn't, that's not what the judge based the decision on anyway.
Exactly. I
Yeah.
mean, it was expressed in the decision as not exactly an afterthought, but just, and also, I don't want the court, make it sound like the court was piling on, but it's just something the court kind of did as a throwaway at the end. But there are certainly the other factors that were explicitly considered by the trial court in this case were more than sufficient to indicate that he had not been rehabilitated. And in any event, even if it could be argued that the rehabilitation was shown, there's no abuse of discretion in this case, and we have to keep in mind that that's the standard of review that we have here. And I just don't think that it could be met in this case. As for the extra statutory authority, this court recently addressed that in In Re AJ 2021 Ohio 3917, indicating that that any of the Pepper Pike kind of remedies or solutions to these cases is properly left to the legislature. It's probably not something that should be judicially created on the fly. And I think the case was well decided, and I don't think there's any way to distinguish the present case from that case.
So even if the adult record had been sealed in this case, there's nothing that he could do to seal the juvenile piece?
I think that's right, Judge, because under Chapter 2151, there are very limited circumstances in which a dismissal will result in an expungement or a sealing, and neither of those has been met in this case.
It just seems really strange.
I think it just indicates that the legislation's kind of cobbled together.
Yeah.
And that it's not a blanket, not a cohesive set of legislation.
So, counsel, it's your position that we could not treat the juvenile case and the adult case as the same case for purposes of sealing and expungement?
I don't think we can, Judge, not under the In Re AJ case. I think that's something that would have to be addressed by the legislature. Unless there are any questions, that's all I have.
That's it. Thank you.
Thank you.
Ms. Moss, you had 3 minutes.
I just want to start with addressing the In Re AJ case. That was solely about dismissal of a case in juvenile court, and we're dealing with a different circumstance. We're talking about the dismissal in adult court, or in adult court, that adult case is eligible to be sealed. And that's the whole point of what Pepper Pike looked at for adult cases, is this ability when the legislator is not clear as the statute, when there's this unusual situation, which we have here. We've passed the probable cause stage, we've moved this case to adult court, and then the case is dismissed in adult court. And that's why this would be an exceptional case where we would urge this court to then utilize Pepper Pike. So I think that this is distinguishable from the In Re AJ case, since that solely concerned the case in juvenile court. As to this court's recent decision in Re LP, I mean, there are some differences between this case and that case. That case did involve numerous charges, including some felony charges for that individual as an adult. So here we're dealing with only of the adult charges being these 2 misdemeanor charges.
But similarly to that case, at least my reading of the trial court's decision didn't really preclude sealing and expungement based on restitution. I mean, they looked at whether the juvenile was sufficiently rehabilitated. That was the thrust of the case, right?
Yes, they did not make it clear one way or another in terms of it solely being about restitution. And that is true here, with the exception of the magistrate making this indication that, that RM had this moral responsibility to pay the restitution order, and that was a factor that she was looking at.
It was a factor, but it wasn't the predominant factor, right?
I don't think you can say one or the other was more or less predominant. I think that those were all factors the court looked at. Additionally, even though the General Assembly directed the juvenile court at all of these factors the court may look at, the court does not have to look at those factors. So the adult charges, certainly the court doesn't have to look at. And the nature of the juvenile court charges, this court has indicated that the nature of the juvenile charges themselves are not a sole factor that the court should look at to deny sealing of records. And just about the standards of review here, because the juvenile court also considered this issue of restitution, then this makes this a de novo review as to all of these factors when you factor in restitution. So if you're looking at the first issue in the assignment of error without restitution, then it would be abuse of discretion, but it would be de novo once you look at the second issue, because that's the court factored in restitution as part of that analysis. So for all of these reasons, we ask that this court reverse the juvenile court's decision and grant sealing expungement of RM's records, or just grant sealing so that the records can be automatically expunged upon his 23rd birthday. Thank you.
Thank you. Thank you both for your arguments this morning. The case is now submitted, and we will issue a timely decision.
Thank you for letting me reschedule this.
Absolutely. No problem. Thank you. Glad you're feeling better.